Good morning. Today is Tuesday, April 14th, 2026. It's 10 a.m. It's my honor to call to order the meeting of the Board of Funeral Directors and Embalmers for the state of Tennessee. Mr. Gribble, will you call the roll?
Yes, sir. I want to put in the record that notice of this meeting today was been noticed on their website since October 10, 2025. This month's agenda was posted on April 7, 2026. Roll call, Tim Wheeler.
Here.
Tim Wheeler present. Don Haynes. Here. Don Haynes present. Tracy Allen.
Here.
Tracy Allen present. Randy Nash.
Here.
Randy Nash present. Scotty Porsche. Scotty Porsche absent. Chris Lee.
Present.
Chris Lee present. Wendell Naylor absent.
Thank you, Mr. Gribble. At this time, we'd like to adopt the agenda.
I make a motion, we accept the agenda.
Second.
Motion by Mr. Wheeler, second by Mr. Haynes. All in favor signify by saying aye.
Aye.
Any opposed, like sign? The agenda has been adopted. Next, in your packet, you have a copy of the meetings from the January meeting that we did not approve at the last meeting. If you will look at those, and we'll entertain a motion in a second.
Make a motion, we accept the minutes for our January 26th meeting. Second.
We have a motion by Mr. Wheeler, a second by Mr. Lee. All in favor signify by saying aye.
Aye.
Any opposed, like sign? Minutes are for the January 13th meeting are approved, and my understanding is we don't have the March 10th minutes today.
They'll be available to next meeting.
Thank you, sir. Next is our legal report, and I will turn it over to you, Mr. Bryant.
Good morning, board members. First complaint is complaint number 2026-012781. This case was administratively opened following a routine inspection conducted on February 11th, 2026. During the course of this routine inspection, the inspector observed the following. The funeral director's license for respondent establishment's manager had expired on December 31st, 2025, and did not meet the requirements to be reinstated until January 8th, 2026. During the unlicensed period, there was no evidence to show that the manager acted in the capacity of a licensed funeral director. However, the individual did remain the manager of respondent establishment without appropriate licensure. Respondent replied acknowledging that the person named as manager of respondent establishment had permitted their license to expire in December of 25. Respondent explained he completed what he thought was all the continuing education requirements in time to renew, but did not recall that 5 of the required CEUs were to be in person. Respondent stated during the unlicensed period from January 1st, 2026 through January 7th, 2026, he was not allowed to wait on families or conduct any services. Respondent advised the issue has since been corrected and explained that it was an oversight and that he is now aware of the CEU distinction moving forward. Based on the above, would recommend a $500 civil penalty to the establishment and a letter of warning to the funeral director, who is the established manager, authorized via consent order, and a formal hearing if necessary.
Thank you, Mr. Bryant, and it's my first day doing this, so please bear with me tell me if I need to correct anything. Any discussion or questions?
Just one question, maybe just for Clarence. $500 civil penalty recommendation on the establishment. Any particular reason in this case for a letter of warning for the funeral director? I know sometimes they're held separately, just curiosity.
Yeah, in this one, there was not a individual case opened against the funeral director. It's more so of just get it on the record. You got it in shape. The primary violation stemming from the establishment, which is the respondent in this case, with the letter of warning just to further, I guess, hammer home the point that, the continuing education and license is your responsibility.
Thank you, sir.
All right, this time we'll entertain a motion in a second.
Motion to approve council recommendation.
Second.
Motion by Mr. Haynes, second by Dr. Allen. All in favor signify by saying aye.
Aye.
Any opposed, like sign? Motion passes. Mr. Bryant.
Next complaint is complaint number 2026-012791. This case was administratively opened following a routine inspection conducted on February 18th, 2026. During the course of this routine inspection, the inspector observed the following. The former manager had been terminated as of January 30th, 2026, and a change of establishment manager application had not been submitted within the 10 days as required. During the time with the out-of-date license manager, respondent performed cremations for 6 decedents. The owner respondent establishment replied, stating that the failure to submit the application was due to a misunderstanding, the belief that they had 30 days to submit the application rather than 10. The owner acknowledged that this mistake was their fault and provided that a new manager was in place as of February 19th, 2026. Respondent stated that during the period without a manager, all cremations were performed by a licensed funeral director. Based on the above, we'd recommend a $500 civil penalty, authorized via consent order and formal hearing if necessary.
Any discussion? I'm the only one with the question. Was this a crematory, a standalone crematory establishment?
Let me check real quick. It is, yes.
We'll entertain a motion in a second.
I make a motion to accept council's recommendation.
Second.
Motion by Dr. Allen, second by Mr. Lee. All in favor, signify by saying aye. Any opposed, like sign? Passes unanimously.
Next complaint is complaint number 2026-012891. This case was administratively open following a routine inspection conducted on February 3rd, 2026. During the course of this routine inspection, the inspector observed the following. The funeral director's license for respondent's establishment manager had expired on July 31st, 2025, and had not been renewed at the time of the inspection on February 3rd, 2026. And the funeral director with the expired license acted as the establishment manager until a change of establishment manager application was received by the board office on January 28th, 2026. Additionally, during the unlicensed period, the manager acted in the capacity of a licensed funeral director by signing the death certificate for one decedent. Respondent acknowledged the 2 preceding violations and acknowledged their failure to update the manager position. Respondent explained they had completed the continuing education hours required for renewal prior to the expiration date. However, quote, there is a breakdown in the process of those completed hours being promptly submitted and reflected with the state, end quote, and thus the renewal was not finalized. Based on the above, we'd recommend a $1,000 civil penalty, authorized via consent order and formal hearing if necessary.
Thank you, Mr. Bryant. Any discussion?
I just have one question. How did council come up with the penalty amount? Because it looks like they went 6 months. Is that correct?
That is, yes. $1,000, typically what this board has done, I guess for a little over the last year since we've seen such an influx of these expiration of license cases, usually kind of the baseline, roughly speaking, is around $250 to $500. This one, as Mr. Wheeler, you pointed out, was a little more severe with going from July, very end of July of 25 until the beginning of February of 26 with an expired license. The $1,000 is representative of an increase of the usual baseline while acknowledging that they do not have disciplinary history. So that's, I guess, kind of splitting the difference in the balance of that recommendation. But again, as always, if the board feels higher or lower is necessary, certainly within your purview.
Go ahead.
Just making sure, during that 6 months, I guess I hate to assume there was more than one licensed funeral director there. They only had one case for the 6 months.
It is my understanding that there were other licensees there.
And so when he goes for that long of a period, were they cited for an expired license or for unlicensed activity?
So one instance of this individual of during that period from July 31st, 25 to February 3rd, 26, where they had done one instance of unlicensed activity, which was signing that death certificate. The primary violation is that you're required to be a licensee to be manager of an establishment. So for that period when they had an expired license, they were not a valid manager, which they were until January 28th, 2026, when I think they realized and then switched the manager out for that reason.
All right. Any further discussion?
Make a motion to accept council's recommendation.
Second.
Motion by Mr. Lee, second by Mr. Wheeler. All in favor, say aye.
Aye.
Opposed, like sign. Passes unanimously.
Next case is complaint number 2026-012771. This case was administratively opened following a routine inspection conducted on February 6, 2026. During the course of this routine inspection, the inspector observed the following. Respondent's establishment name was listed on the website in numerous locations with an establishment name that did not reflect the current name in core. Additionally, signage near the road of respondent establishment had been removed. However, a sign placed on the wall near the entrance of the building displayed the name as the non-licensed name. Respondent replied, stating that they are in the process of changing the establishment name to the name identified on the website and the sign. Respondent stated currently they operate two separate businesses and have maintained original signage at both locations, where the bronze plaque identified was a gift from a vendor, which the contract had installed during a previous remodel. Contractor, excuse me. Respondent stated they did not realize the plaque displayed the new name prematurely, but have covered the plaque until the name change becomes finalized. Regarding the website, respondents stated they contacted their vendors to merge existing sites to ensure all obituaries were preserved and that they did not intend for the original websites to be shut down. Respondents stated there was no intent to deceive the public with the names and that they were administrative oversights. Based on the above, we'd recommend a $500 civil penalty authorized via consent order and formal hearing if necessary.
Any discussion?
I have a couple of questions. What does the TCA code state on something where a name of an establishment is displayed prior to the opening or being approved by the state?
To keep it as simple as possible, whatever your name is in core is what should be reflected publicly. Whatever that name happens to be, registered specifically as a licensee with the state is what all forward-facing signage, website, any contract names, anything should be reflected as.
And is just covering it, does that adhere to the law?
So
Sorry, I slept well last night.
Mr. Gribble knows this. I try very hard not to give the classic attorney answer, which is it depends. But sometimes it depends is the correct answer. I think in this instance where they're referring to the plaque that it's prematurely got a name that will soon be the name in core purportedly, and they are covering it so it is no longer forward facing. I think that is, it's not ideal, obviously. I think it is sufficient to where it is not somewhere forward facing that if someone from the public comes in, they can't see that that plaque has an incorrect name and they're, wait, I thought this was establishment ABC, not ABCD. Not ideal, but I think it's good enough for to avoid violation. Though that does not excuse the, time period that plaque was up and forward facing to the public. So I still think there's a violation there. It's been mitigated to however the board feels, the sufficiency of that mitigation.
So I think that brings up my next question. Do we know how long that sign was up before it was found and then it was covered?
Do not know specifically. What we would know is that from the period of their previous inspection, it wasn't an issue. At some time between now and then, it came up on February 6th when this inspection was conducted. So we do not know with specificity how long that sign was up, but do know that it occurred at some time in between the inspections since it was not a finding on the previous one.
Okay. I guess following and seeing their history, I would like to make a recommendation. We increase the fine to $1,000.
We have a motion by Mr. Wheeler to increase the civil penalty to $1,000. And I'm assuming authorize the consent order and formal hearing.
Yes.
We have a second. The motion fails due to lack of a second. We entertain a motion for the original recommendation.
You saying something, Mr. Mason?
Well, I think I have a question. How long, if you change a name in core or signage and then change your name in core, how long does the state allow? 30 days for all of that to process, I guess? Do you know what I'm asking?
Yes,
For them
I
both to
I
match?
do, and I think that leans a little more administrative. Mr. Gribble, do you, I know the question isn't necessarily how long administratively does that take, but how long is the, I guess, application for a name change open?
Correct, yeah,
Um,
that's a good way to ask that.
In this particular instance, there was no application pending. The inspector showed up, the website had been changed, the new name of the proposed establishment was on the wall. How long it'd been there, I don't know. That was a question the inspector, I don't think, asked. Or if the inspector did, it wasn't included in but when they make an application and we approve it, we understand they may be using the old name for a few days because signs depend on how soon a sign company can come out and sign and change that sign. So I don't think an inspector is going to be back out there next week to make sure they've changed it to the new name. I think what the inspector is looking at, are they changing it prematurely before they file an application or before they're there's an inspection required, and they may be changing their name before they file the application, or they may wait till they file the application and change it before the inspection occurs. And once the inspection occurs, then we administratively review that and approve it. So there are three different places it could occur at: prior to the application, prior to the inspection, or prior to the approval. This one occurred before all three.
So in essence, they got the cart before the horse. They went ahead and did all the changes without filing anything with the state.
That's correct in this particular situation.
Any further discussion? So we entertain a motion.
I'll make a motion to accept council's recommendation, $500 civil penalty, authorized via consent order and formal hearing if necessary.
Second.
Motion by Mr. Lee, second by Mr. Haynes. All in favor, say aye. Any opposed, like sign?
No.
Please mark one no for Mr. Wheeler.
All right, Mr. Nash, with Mr. Wheeler,
Yes.
for the no?
Yes.
Okay. I thought I'd heard Mr.
Sorry.
Lee, but just want to make
Probably need
sure.
to, no, I said Mr. Wheeler, I'm pretty sure.
Yep. Okay, next complaint is complaint number 2026-012811. This case was administratively opened following a routine inspection conducted on February 18th, 2026. During the course of this routine inspection, the inspector observed the following. Multiple prices on the casket displays in the selection room had different selling price than what was shown on the casket price list dated January 1, 2026. Multiple ceremonial rental casket displays in the selection room were not listed individually with the proper identifying information on the casket price list. Respondent replied stating that they were in the process of changing their casket company and remodeling their selection room. Upon being made aware of the violation, respondent stated they immediately contacted the home office, who started working on redoing the casket price list and ceremonial rental casket price list. Respondent indicated that these had since been corrected and provided an updated casket price list. Based on the above, we'd recommend a $750 civil penalty authorized via consent order and formal hearing if necessary.
Any discussion? Entertain a motion at this time.
I make a motion, we accept council's recommendation.
Second.
Motion by Mr. Wheeler, second by Dr. Allen. All in favor, please say aye.
Aye.
Any opposed, like sign? Passes unanimously.
Next complaint is complaint number 2026-012711. This case was administratively opened following a routine inspection conducted on February 10th, 2026. During the course of this routine inspection, the inspector observed the following. After review of the general price list, the veteran package includes a 5% or a 10% discount. applicable only to caskets with a retail price of $3,295 or higher in violation of the funeral rule. Respondent replied stating that, quote, out of respect for this board and its efforts, end quote, they have applied those discounts to all caskets offered effective March 15th, 2026. Based on the above, there appears to have been a violation of the funeral rule. Based on the information provided, it appears that respondent may still be in violation of the funeral rule. Based on the above, we'd recommend a $500 civil penalty authorized via consent order and formal hearing if necessary.
I feel like I have a question, but I'm not sure what it is.
Yeah,
So,
exactly.
I'm
Can
sorry.
you break that down for us? Especially about still, he doesn't, yeah.
So I do have to be careful because that would essentially be providing legal advice to every licensee that would watch this. So where I am is based on the information, did not have a lot of information on this one. This was the only thing that was found during inspection, which that's good that there weren't other things. This is about the extent of the response that I got, that has now been updated. I would encourage the board to just look at what is in front of it. If from the information provided and the response, the board does not feel that there is a continued violation of the funeral rule, that's great. That's ideal. That's what we want. So don't let my commentary, I guess, sway the board, since I am limited on what kind of forward-looking advice I can give. I think we all agree that at the initial time of the inspection on February 10th, there was an applicable violation of the funeral rule. Respondent has made remediation efforts. Whether those efforts satisfy the requirements of the funeral rule is the board's determination. And if that is a compelling mitigating factor to change the civil penalty recommendation. I know that's not very helpful at all, but that's why we came to the $500 civil penalty recommendation, in addition to because they do not have any disciplinary history.
Okay, I can understand the recommendation, and based on this violation of the funeral rule, does this board need to look into any further action as far as follow-up or anything like that to make it clear we're not continuously violating that rule, if that makes sense?
Yes, that is up to the board. I know that this place will be inspected again for routine inspection, just as every funeral establishment is. That can be determined at that time, or if the board feels that a check-in prior to that routine schedule is necessary, we can add some parameter that the inspector go back 6 months from now, 3 months, 8.5, whatever the board feels is appropriate.
So what you're saying, counsel, is it's appropriate that if we approve this, we could put in there that we would like to have the inspector be there within a 30-day period, 60-day period, 90-day period, whatever.
That's correct. And I think even then it could be a term of the consent order. It does not have to be, since the board has statutory authority to conduct those. We're required to conduct them on the routine schedule. We are able to conduct inspections whenever, necessary. So it wouldn't even necessarily have to be a term of the consent order. It could be, but does not have to be.
Okay.
I got one more. You go.
Go ahead.
2 questions. Was this the only violation that was seen during this inspection?
Yes.
And the response seems a little bit defiant to me. Was that the tone of the response?
I would say no. In reading that, I did want to put that phrase in there, not to suggest that it was defiant necessarily, but essentially they took the approach of, hey, you're telling us it's a problem, we'll fix it. They were viewing it as from the veterans package, it was a discount that was being applied to veterans specifically, and they said, hey, if you're telling us this is a problem, we'll adjust it. So I apologize if that
It's okay.
terse response
Yep,
communicates.
It's okay. I just was curious if there's anything else in there that we needed to know about. Mr. Lee, did you have something else?
Just a question for the board. Would the board maybe feel or entertain, and maybe I'm going down the wrong road, maybe table this complaint and allow one inspector at his determination to make another unannounced follow-up and then bring everything to be heard, whether this was a one-time thing and everything's been corrected, or if not, we hear that later? Any thoughts?
That would need to be placed in the form of a motion.
And is that okay, council, that we do something like that?
Yes, definitely within your purview. That does make my case H metric go up just a little bit, but that's okay. If that's what the board thinks is best suited for this one, which I would not disagree necessarily. So
We could approve the civil penalty and add that to it as well. Correct?
I'll entertain a motion. I'll make a motion, I apologize, to accept council's recommendation of a $500 civil penalty, authorized via consent order and formal hearing if necessary, and also prior to the next routine inspection next year, do an unannounced follow-up to make sure they are in compliance.
I'm going to restate it, make sure I'm not missing anything. So your motion is to, for a $500 civil penalty, authorize the consent order and formal hearing if necessary, and also an unannounced reinspection prior to the next inspection,
The next routine inspection
next routine inspection.
to check for
Okay.
compliance.
There's a motion on the floor for
Second.
that. Do I need to restate it again?
no, I think you're okay.
We have a motion by Mr. Lee, a second by Mr. Haynes. All in favor signify by saying aye.
Aye.
Any opposed, like sign. Passes unanimously.
Next complaint is complaint number 2026-007561. This case was administratively opened following a routine inspection conducted on January 13th, 2026. During the course of this routine inspection, the inspector observed the following. Respondent had permitted 3 separate individuals to write pre-need funeral contracts without a proper pre-need sales agent registration. Specifically, one individual wrote 48 contracts without proper registration. The second wrote 10 contracts without proper registration, and the third wrote 1 contract without proper registration. In totality, respondent permitted 59 contracts to be written by individuals without proper pre-need sales agent registration. Respondent replied, stating that upon notification, they assisted the 3 associates in renewing their pre-need sales agent registrations, and that upon being made aware they did not have active registrations, the 3 associates ceased meeting with families and only resumed once they received appropriate registration. Respondent, the manager of the establishment, apologized for the oversight and stated they were under the impression that all licensing was up to date when they took over on August 10th, 2025. Based on the above, we'd recommend a $2,500 civil penalty authorized via consent order and formal hearing if necessary.
Any discussion?
That's a lot of pre-need contracts that slipped the manager as well as 3 licensed agents.
Entertain a motion.
How did council come up with $2,500 with so many contracts being written?
With that one specifically, what was primarily considered is kind of do the scale of severity of, with 59 contracts, that is a lot. In 2025, they were also cited for violation of prearrangement or pre-financing in the amount of $500 civil penalty. Likewise, there are complaints opened on the pre-need side for the 3 associates, and those have not been determined at this time, but will be shortly. So it was kind of in totality of that, but again, recognizing that 59 contracts is a lot. I can share too that the response states that this manager took over on August 10th, 2025, and they thought everything was all good. Everything was in good shape with the registrations. From my recollection, particularly the one that wrote 48, those stemmed from February of 2025 through December. So not registered prior to the new manager, not registered prior or after the new manager came on. It was in their responses, they likewise said it's similar to what we've heard in these kind of cases before, where I thought I only needed an insurance producer's license. I didn't realize I needed a pre-need sales agent registration as well. So a lot of different polling factors, some from other cases to get to the $2,500. But as always, if the board feels that an adjustment of that is needed.
Any other questions? This time we entertain a motion. In a second.
I'll make a motion that we accept council's recommendation, $2,500 civil penalty authorized via consent order and formal hearing if necessary.
We have a motion to accept this recommendation. Do we have a second?
Mr. President, I will withdraw that motion for further discussion by the board.
We have further discussion, or do we need, is there someone that would like to make a different motion?
I guess I have a question. Well, probably not a question, just more of a, is this, has, in your knowledge, has this many pre-need contracts ever been written without registration? And I know I'm putting you on the spot and that's okay. I'll keep talking for a second. Because just in my point of view, that penalty doesn't even get close to covering how much was written in 59 contracts. Right? So and again, maybe I'm just thinking it needs to be a little higher, but. that's
Sure.
just my
And
personal opinion.
yeah, and one thing I will say too, I've shared this with the board members previously. I don't think I've said this since you've come on, Dr. Allen, but typically I'm going to lean a little more conservative in recommendations for a few reasons, but one of which is I've learned a lot about this industry in the last 5 years. I do not know a fraction of what you all do. So I kind of baked into those recommendations are the understanding that I will lack some of that institutional knowledge. And if something triggers that this feels really low or this feels high, follow that instinct. You all are the ones who know, not me. To answer your first question, I don't know that I may have seen ones around this high. One does not come to mind that was like, oh no, this one was way higher than this one. This is, I would say, hovering around the highest that I've seen.
Okay, and then a follow-up. You mentioned just a moment ago, so each of these individuals, they will get paperwork regarding that
The burial service.
on the burial side. Okay.
Correct.
So there lies my question for those people of those 59 contracts written. If someone dies and that contract has not been correctly signed by everybody, what happens to that family?
Well, you got me twice in one board meeting,
That-
Mr.
that-
Wheeler. It depends.
That was my question, was the validity of the contract.
That's something that I think a court of competent jurisdiction would need to determine.
Really?
We can get into the specifics of the implied intent was to have a licensee to sign it. Is that good enough for the contract? Is it not good enough? Do you need someone else to step in as co-signer? I think there are a lot of questions that would depend on the individual circumstances in front of them. And if it ever got brought up or challenged in the first place. So it's something I think would extend into a separate court.
So I guess therein lies my question. So we have 59 consumers, or however you want to look at it, that, were not properly taken care of by the law. Steps weren't followed. So I always worry about the consumer.
Sure.
That is the main person we should be concerned about, is the consumer, and does it affect that consumer if something happens and the paperwork has not been 59's a lot in my book, and especially to go from February of 25 to December of 25. I mean, you're talking 11 months. And again, I guess, and this might be something for Mr. Gribble to answer. So that person who has the pre-need license, they go in knowing what they're supposed to have a valid license. Is that correct?
Well, each licensee or each registrant is responsible to know the laws and rules. Whether they do or not, obviously on the funeral side, funeral director and embalmers take a Tennessee laws and rules exam pertaining to the funeral laws and the pre-need laws. But someone just obtaining a pre-need sales registration is not subject to a law test.
Okay.
But they're still responsible. I think council would agree, they're still responsible to comply with the laws and rules and know what those are.
I'm assuming that they're three different individuals in that period is probably a larger operation that, for lack of a better term, is trying to fill positions and, it's hard for me to, I mean, that when they took over on August 10th, they were under the impression, but they didn't verify that, and so that's the other thing. There was one question I was going to ask. So it says in here that responded reply stating that upon notification, they assisted them with renewing, and then when they were made aware they did not have it, they were active registrations, they ceased meeting with families and owners and once they receive appropriate registration. So I guess my other thing was that we had, they say that in this response, but I kind of would want verification of that too.
I have a
So-
question. Do you know who the underwriter was for all these policies?
I do not. No.
Well, when we write a pre-need, we have to put a registration number on it, and I'm just wondering if that was left blank. And why would the underwriter accept it if it was left blank?
And this is purely a guess. My guess would be that because they did communicate that they had an insurance writer's license. My guess would be that they may have put that identifying information in there, which may have been enough for it to get through the underwriting. I'm not completely sure. That's just a guess, because I agree. If I were the underwriter and had a blank registration number, that would throw up some red flags.
So if I'm doing this wrong, tell me. So at this time, it sounds like that we, if someone want to make a motion to amend this,
One more question, then I'll do that. Can you give us quickly the parameters on what fines can be levied per violation? Is that general knowledge?
Yes, the board is permitted to do up to $1,000 per day per violation. So you have 59 contracts here that were written by individuals who were not properly registered. Your ceiling is $59,000. Your floor is, you could do 250 as your floor.
if you break it down right now, it's about $43 per violation. So I already did that. Not in my head, on my calculator.
I'll make a motion that we amend the civil penalty to $5,900, authorized via consent order and formal hearing if necessary.
Second.
The motion on the floor from Mr. Lee is to amend the civil penalty to $5,900, authorized via consent order and formal hearing if necessary. The motion has been properly seconded by Mr. Haynes. If all are in favor, please signify by saying aye.
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 Any opposed likewise? That passes unanimously. Back to you, Mr. Bryan.
Next complaint is complaint number 2026-011-381. This case was administratively opened following a routine inspection conducted on October 27th, 2025. During the course of this routine inspection, the inspector observed the following. So in advance of this, before I get started into this one, the next These set of four are the same essentially. It's as I will explain in the lengthy summary here, it was a corporate merger that required a change of ownership for these four. So the facts are identical. We may have at one point, or a date may say February 27th and maybe February 26th for the other one. Other than that, they are essentially identical. So we do the heavy lifting on the first one, and then the next three should, I would say for consistency's sake, be identical, if not very similar.
These are on the same establishment.
No, they are different establishments, but the corporate merger that occurred requiring the underlying change of ownership is the same. It's the same merger that encompasses all four of these.
I understand.
During the course of the inspection, the investigator determined that respondent had failed to provide all required documentation necessary to complete the ownership change process. On February 9th, 2026, a follow-up reinspection was conducted at respondent establishment, where a notice of violation citation was issued regarding the change of ownership application, where the entity of the correct documentation was not submitted to finalize the application. Entirety of the correct documentation, excuse me. The investigator noted specifically Rule 0660-06-.03, which states that, quote, a new owner shall apply for a new establishment and shall not operate more than 75 days without either issuance of a new license or appearing before the board and obtaining an extension of time, end quote. Respondent replied that as of October 8th, 2025, an entity merger occurred which triggered the requirement for a change of ownership application to be submitted. This application was submitted via CORE on October 16th, 2025. Following the receipt of this change in ownership application, the on-site inspection occurred, and on November 7th, 2025, the inspector advised respondent that they lacked what he believed to be adequate documentation regarding the sufficiency of the zoning and parking at respondent establishment, as well as documentation regarding the sewer or septic tank. Respondent remained in consistent communication with the inspector, providing a copy of the prior zoning parking letter it had received when the organization originally obtained respondent establishment. However, the inspector informed respondent on December 5th, 2025, that this documentation could not be accepted because it was not current. Likewise, respondent advised the inspector that the city was not responding to their request for a letter regarding the city sewer system. Respondent stated they continued to work to obtain the relevant documentation, and on February 26, 2026, an acceptable letter was received and provided to the inspector on March 3rd, 2026. Additionally, due to an internal miscommunication, the individual working on the project learned that respondent was not connected to the city sewer system, explaining why the city had been unable or reluctant to assist, and realized that they were on a septic system. Accordingly, the system was inspected and the report was emailed to the inspector on March 3rd, 2026. As of March 3rd, 2026, all outstanding documentation has been received, stemming from the original application submitted on October 16th, 2025. Respondent acknowledges that it failed to appear before the board to request an extension of time when more than 75 days had passed since the submission of the change of ownership application, but they offer that they were in, quote, somewhat regular communication, end quote, with the inspector and provided updates regarding the difficulty in obtaining sufficient documentation. Likewise, respondent acknowledges that they failed to comply with certain rules relevant to its business despite their best efforts to do so. Respondent stated they genuinely attempted to provide the requested documentation, but encountered delays due to the holidays and the slow responsiveness of various local authorities. Respondent stated, quote, we recognize its obligation to adhere to the board's rules and regulations and sincerely apologize for its failure to do so, end quote. However, respondent indicated that all outstanding documentation has now been submitted. So the four rules we have at play here, the inspector cited respondent for the following violations. The aforementioned one, Rule 0660-06-.03, change of ownership, requires the licensee to submit the application and not operate for more than 75 days without receiving the new license or appearing before the board to request more time. Respondent acknowledges that they operated more than 75 days while in contact with the investigator to submit all the required documentation. Respondent acknowledges that they did not appear before the board to request additional time. 137 days passed between the application and the final submission. Rule 0660-06-.04, inspection required. This requires an inspection of an establishment prior to approving a change of ownership application. It could perhaps be argued that by failing to provide sufficient documentation, respondent did not comply with the parameters of the inspection. However, it appears that respondent attempted to comply and sent follow-up documentation upon request. Without question, an initial inspection and follow-up inspection of the respondent establishment did occur. It is legal's opinion that respondent did not violate this rule. Third rule in play is Rule 0660-06-.012 application. This requires an application for an establishment license to be fully completed by the applicant within 90 days. It requires any incomplete license or application to be closed after 90 days. Respondent admits the application was not completed within the 90 days. Respondent stated this was due to delays with local municipalities regarding necessary documentation involving zoning and sewer/septic systems, and that they were under the impression that due to the consistent communication, the application remained open. Respondent stated now that they had the correct documentation, they were prepared to file the application again if the board determined the initial application should be closed. And finally, Rule 0660-01-.031 changes. This requires that a change of ownership be reported to the board within 10 days of the effective date of change. Respondent provided that the merger change requiring a change of ownership application occurred on October 8th, 2025. Respondent submitted the application on October 16th, 2025 within the 10 days as required. It is legal's opinion the respondent did not violate this rule. Based on the above, we'd recommend a $750 civil penalty related to the violation of Rule 0660-06-.03 for failing to appear before the board to request additional time after respondent continued operating past the 75-day period since the change of ownership application had been submitted. Authorized via consent order and formal hearing if necessary.
Catch your breath, Mr. Bryant. Any discussion or questions?
Motion to accept council's recommendation.
Second.
We have a motion by Mr. Lee to accept the recommendation of council, a second by Mr. Wheeler. All in favor signify by saying aye.
Aye.
All opposed, like sign. Passes unanimously. Thank you, Mr. Bryant, for your details on that.
Thank you all. Next complaint is complaint number 2026011391. This again is complaint 2 of 4 that are identical. This case was administratively opened following a routine inspection conducted on October 27th, 2025. During the course of that inspection, the investigator determined all necessary documentation had not been submitted. On February 9th, 2026, a follow-up reinspection was conducted. Notice of violation was issued regarding the change of ownership application, and the investigator noted specifically Rule 0660-06-.03, which stated that a new owner shall apply for a new establishment and not operate more than 75 days without either issuance of a new license or appearing before the board and obtaining an extension of time. Respondent reiterated their response from the previous complaint. Legal would reiterate their analysis from the previous complaint and would recommend an identical recommendation of $750 civil penalty, authorized via consent order and a formal hearing if necessary.
Entertain a motion in a second.
I make a motion, we accept council's recommendation.
Second.
Motion by Mr. Wheeler, second by Dr. Allen. All in favor signify by saying aye.
Aye.
Any opposed, like sign. Passes unanimously.
Next complaint is complaint number 2026011401. Complaint number 3 with the same identical facts. Case was administratively opened following a routine inspection on October 23rd, 2025. A follow-up examination conducted on February 10th, 2026, where they were issued a notice of violation citation, specifically regarding the change of ownership application, where the new establishment shall not operate more than 75 days without either issuance of a new license or appearing before the board and obtaining extension of time. Respondent reiterated their response from complaint number 8. So based on the above, legal would make a identical recommendation of $750 civil penalty, authorized via consent order and formal hearing if necessary.
Entertain a motion in a second.
I make a motion, we accept council's recommendation.
Second.
Motion by Mr. Wheeler to accept recommendation, second by Mr. Lee. All in favor signify by saying aye.
Aye.
Any opposed, like sign. Passes unanimously.
And next is complaint number 2026-012-741, the fourth of our 4 complaints with identical fact patterns. Again, this one was open following a routine inspection conducted on October 28th, 2025. A follow-up inspection was conducted on February 11th, 2026, where they were cited with a notice of violation, specifically for a new owner shall not operate, or shall apply for a new establishment and shall not operate more than 75 days without either issuance of a new license or appearing before the board and obtaining an extension of time. Respondent reiterated their response from complaint number 8. Therefore, legal would make an identical recommendation, $750 civil penalty, authorized via consent order, and formal hearing if necessary.
Entertain a motion in a second at this time.
Motion to accept council's recommendation.
Second.
Motion by Mr. Haynes, second by Mr. Lee to accept council recommendation. All in favor signify by saying aye.
Aye.
Any opposed, like sign? Passes unanimously.
Next complaint is complaint number 2026-007251. Complainant, wife of the decedent, stated her husband, quote, suffered a major cardiac infraction, end quote, on or around December 2nd, 2025. Complainant appears to allege that respondent and their marital partner, quote, threatened and verbally assaulted, end quote, the decedent to execute a new will. Complainant alleges that respondent and their partner misled the decedent into believing that they had the authority to create and execute a will, stating, quote, my husband was unknowingly misled and unaware that each time he made any changes to the will that respondent and partner helped him create, that they were calling his stepchild from his first marriage to their mother to inform them of any requests or wishes that he made, end quote. Complaint also alleged respondent, quote, knowingly provided deliberate, intentional, misleading, false statements and details of information for purposes and reasons to aid their cousin in illegal transactions to retain access or gains of insurance monies and assets of the deceased, end quote. Complaint does not provide any documentation or information to support these claims. Complaint only attaches the death certificate for the decedent and an obituary of an individual who passed in February of 2023, which does not appear to be the decedent in question. Complainant does not carry their burden regarding the allegations contained in the complaint. First, though one probably should consult an attorney, you do not have to be an attorney to draft or execute a will. The complainant does not provide a copy of the will that respondent is alleged to have misled the decedent into signing. Not being an attorney while drafting a will or assisting in drafting of a will is not in and of itself a violation of any law or statute. If complainant believes the will was executed through duress, that is for a court of competent jurisdiction to determine, not this board. Complainant does not provide any actionable information for this board to determine that any violation has occurred, and therefore has not carried their burden for the complaint, so we'd recommend closure.
Motion to accept council's recommendation.
Second.
Motion by Mr. Lee, second by Mr. Wheeler. All in favor signify by saying aye.
Aye.
Any opposed, like sign? 13.
Next complaint is complaint number 2025-076411. Complainant, daughter of the decedent, stated their mom passed away on October 21st, 2025, and did not receive cremains until December 18th, 2025. Additionally, complainant stated they paid for death certificates, but that respondent did not have death certificates available for pickup when receiving the cremains. Respondent replied, stating that the decedent entered their care on October 23rd, 2025. Complainant was given the pricing and were told they would need another signature since complainant was not the only sibling. Respondent reported that infighting among the siblings occurred, but that ultimately the authorization form was completed. Respondent stated they advised complainant that once the death certificate was signed, they would be able to sign as well. Respondent stated they provided complainant a working copy of the death certificate for reference. Following this, respondent provided that complainant, quote, begin to come to the funeral home every other day to check the status of his mother, end quote. Respondent stated they checked for RISM every day and called the primary physician that had been provided by complainant. However, the primary physician refused to sign the death certificate, and it was explained to complainant that they would reach out to the hospital to try and find another doctor to sign. Respondent stated the death certificate was finally signed on November 18th, 2025, and was immediately faxed to the medical examiner. Permission was given on November 24th, 2025, and the permit issued on November 26th, 2020. That should be 2025, sorry, not 26. The day before Thanksgiving. On December 1st, 2025, when the health department opened after the holiday, the cremation was scheduled and this date was shared with complainant. When the cremation had been completed, complainant was informed the cremains were ready for pickup. While the complainant was present, the attendant checked on the status of the certificate and was told that they were waiting for the health department to call them when the list of death certificates were ready. Respondent suggested to complainant that if a death certificate was needed immediately, they would reimburse complainant the $15 for him to pick one up from the Department of Health, or they could wait until their copy was ready. Based on the above, the death certificate was signed on November 18th, 2025. Respondent could have obtained a certified copy of the death certificate on this day rather than waiting for their copy to come through. Further, respondent did not provide information regarding the release of the death certificate or what day the certificate was released in Verizon. We would recommend a letter of warning.
Questions or discussion?
I make a motion to accept council's recommendation.
Second.
Motion to accept recommendation by Mr. Lee, second by Mr. Haynes. All in favor signify by saying aye. Any opposed, like sign? Passes unanimously.
Next complaint is complaint number 2026-007781. Complainant, sister of the decedent, stated that respondent came to pick up their brother's body on December 23rd, 2025, and that the contract was signed and paid for on December 26, 2025. Complainant alleged that after 2 weeks, the death certificate was still not completed. Complainant stated they called a respondent on January 7th, 2026, and were told that they had been trying to find the decedent's social security number because complainant was unable to provide it at the time of the agreement, though complainant stated they would search for it. Complainant claimed they had not received a call from respondent. Additionally, complainant provided that they called respondent on December 31st, 2025, regarding the decedent's obituary, which had not been posted. Complainant stated that they were told it was due to a glitch and that it would be reposted. Complainant stated during this conversation they inquired as to whether they had found the decedent's social security number, but did not hear back from respondent, which prompted the call on January 7th. During this call, complainant stated they were told they had gotten the decedent's social security number, and complainant received the death certificate on January 8th. Complainant also stated they were told that they should receive the cremains the following week. Complainant called the respondent again on January 21st, 2026 to inform respondent they had not received the cremains. Complainant purports that they were told that they would speak to the manager, and complainant indicated that as of the date of filing the complaint, February 3rd, 2026, that they had not heard back from respondent. Respondent confirmed that the decedent entered their care on December 23rd, 2025, and that the arrangement conference occurred on December 26, 2025. Respondent stated that during the arrangement conference, neither the mother of the decedent nor complainant could provide the decedent's social security number, but that respondent, quote, assured them we would assist them with locating that information as it is required before a death certification can be obtained from the state, end quote. Respondent stated they never received a call from the family member with the social security number, but were able to obtain it from a medical provider on January 7th, 2026. The decedent was cremated on January 12th, 2026. Respondent stated that they received the urn ordered by the decedent's mother on February 2nd, 2026, and that once the urn was engraved, it was delivered to the mother's place of residence on February 20th, 2026. Respondent further provided, quote, we acknowledge delays between the decedent's cremation and delivery of his urn, and we apologize to the family, end quote. Legal determined that decedent was in the establishment's care for a total of 59 days, with a 38-day delay between the cremation and delivery of the cremated remains. The respondent, however, stated that the urn was not received until February 2nd, 2026, and the cremated remains were delivered on February 20th, 2026, an 18-day interval. Based on the above, we recommend a $500 civil penalty, authorized via consent order, and formal hearing if necessary.
Any discussion or questions?
Motion to accept council's recommendation.
Second.
Motion to accept by Dr. Allen, second by Mr. Wheeler. All in favor signify by saying aye.
Aye.
Any opposed, like sign? Passes unanimously.
Next complaint is complaint number 2026-008401. Complainant, wife of the decedent, stated that their husband passed away on August 6, 2025, and claimed that they had prepaid arrangements with the respondent establishment. Complainant came to respondent establishment on August 11, 2025, for the arrangement conference and were told that they did not have a record of the prepaid contract, and alleged that respondent, upon showing them the body, said it would be $250 to embalm the decedent, which complainant claimed respondent was already supposed to have done. Complainant stated that respondent asked if the decedent was to be embalmed, to which complainant responded, yes. This conversation was on Friday, August 8th. However, 4 days later, the establishment had yet to embalm the decedent. Ultimately, the complainant decided to have the decedent transferred to another funeral home. Respondent replied stating that the decedent passed on August 7th, 2025, and that the decedent came into their care the same evening, where he remained until transfer per complainant's request on August 12th, 2025. Respondent stated upon the initial call, they performed a thorough review of their records and could not locate any prepaid funeral arrangement or funded funeral contract for complainant or the decedent. Respondent stated before any funeral service arrangements were finalized or contracted for, complainant requested the decedent be transferred to another funeral home. Regarding the embalming, respondent stated that they did not receive written authorization to embalm the decedent, and in the absence of such authorization, embalming could not be performed. During this time, the decedent was maintained under refrigeration in accordance with their standard procedures. Complainant did not provide a copy of the purported pre-need contract or any documentation to show that respondent had a prearranged contract with respondent establishment. Based on the above, respondent may not have received written authorization, but did receive oral authorization on Friday, August 8th, 2025. Respondent could have proceeded with embalming based on this oral authorization, did not, which led to a 4-day delay from the date of approval until the decedent was transferred. Based on the above, we'd recommend a letter of warning.
Questions or discussion?
How did you come up with a letter of warning? Because for those of us that are licensed embalmers, once you're given verbal permission from the family gives you verbal permission to embalm, you take care of it. So in essence, a delay of 4 days can inhibit the embalming procedure and the ability for the person, the decedent, to look as best they could have had it been done prior 4 days earlier. So I guess that's my question. How did you come up? Because we see several violations of other things this firm has had.
Yeah, so this is one that Mr. Gribble and I talked about a little bit, just one of those that I think are kind of rich in industry knowledge to help fill my gap. And I think one thing that may have been at play with that delay as well, respondent doesn't allude to it, but if you have complainants saying, no, we've already paid for embalming, we have a pre-need contract, and you're tearing the office apart to find the contract and you can't find it. I could see a scenario that respondent is in where if they embalm and your customer thinks we've already paid for it, you're going to embalm and then you're not going to get paid for that service because they believe there is a pre-need contract that they've already paid for. I that may not be appropriate for me to read that in, but it does appear to me that some of the calculus that was occurring, when complainants provided their information, it seemed that they ultimately decided to transfer based on this disagreement regarding the pre-need contract, and that the embalming was kind of the final straw, so to speak. So with all of that considered, it was a letter of warning that they do have that verbal authorization. I understand probably preferred to get written authorization, which I totally get, but that they did, exactly as you said, Mr. Wheeler, kind of put themselves in a situation where you're the decedent's in your care for 4 days and it's in refrigeration, which is great, but they did have verbal authorization on the 8th. So all of that weighted together was a letter of warning. But again, if, the board certainly can go higher.
Out of curiosity, this was August of last year. Did they ever find a pre-need or was the family mistaken?
I don't know that for certain. I do think it's a little telling that the complainant did not attach a copy of that contract or the purported contract. I think that would be one thing, that if the complainant had walked into that arrangement conference and said, no, here's the contract, we do have it, then I don't know that there would be a problem in the first place. So I can't say that with complete certainty in either direction. If I were to guess, I would think complainant probably did not have a contract.
Well, I think everybody here has probably dealt with that situation where a family came in and said, well, we've got a pre-need with you and you can't find it. So
When was this complaint filed?
I want to say in February of this year, but I can double check that for sure.
but it was in 2026 and he died. This person passed away last year.
Yep, correct.
Any other question or discussion? Entertain a motion at this time.
Motion to accept council's recommendation.
Second.
Motion by Mr. Lee to accept recommendation of council, second by Mr. Haynes. All in favor signify by saying aye. Any opposed, like sign? Passes unanimously.
Next complaint is complaint number 2026-010081. This complaint was administratively opened following an email from an employee at the Department of Health. The employee alleged that respondent was, quote, fraudulently copying a piece of security paper and is issuing what they claims to be certified copies to the decedent's family, end quote. And that was of the death certificate. I'm realizing reading that now, that doesn't make that clear. Complainant stated this was discovered when a death certificate was submitted to them for correction, and upon inspection discovered it had not been issued by their department, but by respondent. Complainant theorized that respondent had scanned or made a copy of a certified death certificate previously issued by their office. Complainant provided that the version of this document had not been in circulation for the better part of 2 years. Complainant further provided that the document had several built-in security features, one of which is that when the paper is copied, the word void is embedded in different locations throughout the paper. Complainant stated it appeared respondent had, quote, altered that piece of paper to be blank on the interior of the page so that new copies of death events could be laid on the document, end quote, so that void would not be present on the page. Complainant stated respondent then printed a funeral home copy that was previously designed to be used when the paper process was still in effect, and individuals needed this document to show insurance companies. Complainant stated on the funeral home copy, the following disclaimer is supposed to be present. Quote, this document is not a certified copy. Pursuant to 10 Code Annotated Section 56-7-206, this document may only be used for purposes of establishing proof of death as it relates to a life insurance policy with a value of $15,000 or less, end quote. The copy that complainant provided, signed by respondent, does not state the above, but states the following, quote, I hereby certify the above to be a true and correct copy of the original certificate of death on file with the Tennessee Department of Public Health Division of Vital Statistics, Nashville, Tennessee, end quote, with respondent signature and date of signature. Complainant provided a screenshot of the document complainant was using that stated it was a certified copy. Complainant stated they reviewed the amount of death events registered from respondent establishment and the amount of death certificates requested. Complainant claimed that most funeral homes order 3 to 5 death certificates for families, and when evaluated as a whole, this had cost the department approximately $61,395. Complainant indicated that respondent had 828 death events since 2018, multiplied by 5 for 5 copies of the death certificates at $15 each, offset by the 47 certificates respondent had ordered since 2018 to reach this estimated number. Respondent replied stating that several years ago, with the implementation of the Verizon system, the process of handling death certificates became more efficient and available to funeral home and families. Respondent stated they began receiving a funeral home file copy, which established a process for them to provide proof of death for some insurance policies and other related items, and thus they did not have the same need to order certified copies except upon request. Respondent stated due to the increased cost of certificates and to keep them off the statement of expenses, they would refer families directly to the local health departments when possible. Respondent claims they have never copied a certified copy of a death certificate, but they have used their office copy, quote, as instructed in the TCA with their own sworn statement added, end quote. Respondent stated they have not removed the registrar's signature or statement of authorization. Respondent stated they had been under the impression from the information provided that they were within their legal limits. Respondent stated in light of the complaint from the Department of Health, they, quote, can see how they would object to a loss of revenue from death certificate sales, end quote, but provided that they have never sold or charged a family for any copy of a certificate that was provided to them. However, respondent objected to complainant's claim to count the number of deaths since 2018, estimate 5 copies per funeral, $15, quote, is far from a realistic figure, end quote. Respondent stated due to the Department of Health concerns and objection, they will gladly change their procedures and, quote, not continue to offer certificates with any authentications given by the funeral home, end quote. Based on the above and information provided, the statement on a respondent's copy is incorrect, as it is not a, quote, true incorrect copy, end quote, because the death certificate has since been changed. Vital Records apprised the department in their complaint that the copy respondent is currently utilizing has not been in circulation for a few years and thus is no longer a true and correct copy of the official document from Vital Records. Likewise, respondent, in attempting to make the quote funeral director certified copies, used authentic stationery documents, which gave a higher inference that it was an official document from Vital Records, which could mislead families, albeit unintentionally. Therefore, for violation of professional conduct standards, legal recommends a $750 civil penalty authorized via consent order and formal hearing if necessary. And not to jump ahead of it, but the next complaint is the funeral director of this complaint. So those two go together, and there will be a separate recommendation for that one as well.
Questions or discussion?
So basically, they were, I guess, going to the print death certificate feature in Verism, but they already had their particular paper with additional writing on it that the death certificate printed on?
That's my understanding. This one was, I've never been in Verism, so complaints talking about Verism specifics can get a little tricky for me to visualize what's happening. But in speaking with the complainant and Mr. Gribble and understanding that's my understanding, that basically they were under the impression that they could create their funeral home copy, were using certified copies and had a disclaimer that did not match the required disclaimer. Likewise, because they were doing that and leaning on the old version they had, when Vital Records updated that death certificate approximately 2 or so years ago, what they were claiming was a true and accurate copy was no longer true and accurate.
Do we know if they were charging the families $15 a copy for their death certificates?
We do not know that. They say that they don't pass those costs on to the family. It says that they have never charged for a certified copy, and then they said they try and refer it out to departments of health when they're able for families. So we don't have that information either way, but respondent claims that they have not.
In the response, they state the quote as instructed in the TCA with their own sworn statement added. And I know that in the TCA at the top is on the bottom of when we print what's called a funeral home copy from Vision, that's printed on there already. But did they notate that TCA, or did you look that up?
They notated it. They cited, or let's see.
Because it's not the same as the one at the top.
Right, exactly. So therein lies part of the problem.
Any other?
Yeah, I got a question. Is it abnormal to hear from the department on complaints just about death certificates? I'm just curious. That was.
Yeah, I would say uncommon. We've gotten some over the years since I've been here. I'd say we've probably had about 5 or so complaints stem from Vital Records reaching out. We, I would say, have a good relationship with our staff over there, and they help us. We help them when we can.
Normally it's for delays.
Yeah.
A lot of times.
Correct. Yep.
All right. Any further discussion? Entertain a motion at this time.
A motion to accept council's recommendation.
Second.
Motion by Dr. Allen to accept the council recommendation, second by Mr. Lee. All in favor signify by saying aye. Any opposed, like sign. All right, number 17.
Next complaint is complaint number 2026-010121. Respondent is the funeral director who, quote, certified the copies and manager of the funeral establishment from the previous complaint. Complainant and respondent reiterated their complaints and responses for this complaint. So we'd recommend a $250 civil penalty against the respondent funeral director's license, authorized via consent order and formal hearing if necessary.
Any questions any questions or comments?
Motion to accept council's recommendation.
Motion by Mr. Lee to accept recommendation, second by Mr. Wheeler. All in favor signify by saying aye.
Aye.
Any opposed, like sign.
Next complaint.
Passes unanimously.
Sorry, is complaint number 2026-010311. Complainant, a former employee of respondent establishment, alleged unprofessional conduct in violation of the funeral rule. Specifically, complainant stated that they had signed a contract with the respondent's previous owner in 2017. Complainant provides a litany of information and details that do not appear to be relevant to their allegation of unprofessional conduct or violation of the funeral rule. Most of the information included in the complaint is not within the jurisdiction of this board and would be in the realm of an employment dispute. One such instance involved the title of a truck, where complainant admits that the filing of the complaint stems from these employment disputes, stating, quote, "After no update about the bills of sale or truck titles, I, complainant, begin this complaint to the Tennessee Board of Funeral Directors," end quote. Complainant claims that in the process of filing this complaint, they, quote, "found a numerous amount of hidden fees that should be illegal to charge families for," end quote. For example, complainant alleged that several times they would go to a cemetery to find that no grave had been flagged or located. Complainant appears to allege that this was indicative of respondent charging families for a service that was not provided, stating, quote, "I complained about them not marking graves for nearly 4 years, and it never got resolved, yet it's showing up in their general price lists, a reason for the charge," end quote. Notably, complainant does not allege that the service was not performed, just that it had not been marked with orange flags that the employment contract stated it would be. Complainant also appears to point to the price of these services as inflated and thus a violation of the funeral rule. Complainant also details, quote, "horror stories," end quote, that appear to be purely anecdotal. Complainant does not provide any evidence other than their claim that such horror stories occurred. Complainant stated that they met with new corporate management regarding the marking of the graves, and a new payment agreement was set up that complainant stated, quote, "After my wish was to see families only pay what I billed the funeral home, nothing more, nothing less," end quote, and it was verbally agreed. That is, as legal understands it, complainant indicated that respondent's profit margin was a violation of the funeral rule and that respondent could not charge families more than what complainant was making for opening or closing the grave. Finally, complainant types out what they presumably comes from respondent's general price list. Complainant only types this out. They do not include a copy of the GPL in the complaint, and thus these numbers are not authenticated. These numbers continues complainant's theory that respondent cannot charge, excuse me, more than complainant charges respondent. Pointing to an example of his fee for opening and closing is $485, but respondent charges $750 to the family. Again, complainant's entire complaint seems to hinge on this understanding that a family is being overcharged if the family pays more than what the underlying services cost. Respondent replied stating that respondent ended their business relationship with complainant in February of 2026, which they state leads them to reasonably assume this complaint is filed in response to complainant's termination. Respondent attached 4 separate sample contracts and state that, quote, "Anytime families paid for complainant services, these were done either via a cash advance, for which no additional charges were levied on families, or via a non-cash advance, other professional service expenses for which respondent was entitled, if it chose, to charge more than its internal costs." Respondent also points that the respondent establishment has undergone several routine inspections by the department during the alleged period to current, which was 2017 through 2026, and that no violations were found relevant to this complaint. Based on the above, complainant does not provide any actionable evidence of violations for unprofessional conduct or violation of the funeral rule. If complainant believes respondent violated their employment contract, any such complaint should be filed with a court of competent jurisdiction and not this board. Therefore, we would recommend closure.
Any questions or concerns?
Motion to accept council's recommendation.
Second.
Motion by Mr. Wheeler to accept recommendation of council, second by Dr. Allen. All in favor signify by saying aye.
Aye.
All opposed, like sign. Passes unanimously.
Next complaint is complaint number 2026-011421. Complainant alleged that respondent failed to provide 8 certified death copies of their mother's death certificate that were ordered and paid for on December 7th, 2025. Complainant states they were told it would take 5 to 8 business days to receive them, but that over 2 months later, despite repeated attempts, they have yet to receive the certificates. Complainant stated they have contacted the funeral establishment on multiple occasions and only received empty promises. Respondent stated the decedent passed away on December 7th, 2025, and arrangements were made with the family. However, the doctor assigned to the decedent did not sign the death certificate until January 8th, 2026. Respondent stated they kept a good rapport with complainant during the entire process and kept complainant informed about the status of the death certificate. Once the death certificate was signed, respondent called complainant, it was proofed and then registered. Respondent then stated, quote, "From this point, we thought her death certificates were sent. It is with our heartfelt apology that she was given empty promises," end quote. Respondent stated after receiving the complaint, they called complainant, personally apologized, and reprimanded the employee who had previously spoken with complainant. Legal called complainant and confirmed that the death certificates had been received and that she had appreciated complainant's apology. Based on the above, we recommend a $250 civil penalty, authorized via consent order and formal hearing if necessary.
Any comments or questions? Entertain a motion to accept.
Motion to accept council's recommendation.
Second.
Motion to accept recommendation by Mr. Haynes, second by Mr. Wheeler. All in favor signify by saying aye. Any opposed, like sign. Passes unanimously. Number 20.
Next complaints, complaint number 2026015151. Complainant states they work across the street from respondent and that quote, on almost daily or multiple times a day, there is a nauseating burning smell coming from the crematory, end quote. Complainant claims the smell infiltrates surrounding buildings. Respondent replied stating that as of February 2024, a brand new CFS 3000 crematory machine was installed at the facility. The machine was serviced on November 24th of 2025. Respondent stated they keep in consistent communication with the manufacturer anytime there are issues and that they have not pointed out any abnormalities that would cause a smell. Likewise, the crematory operator or any employees do not smell any consistent odor. Respondent also provided that there are 2 other crematories in the immediate area and a coffee roaster. Respondent explained the crematory begins its day on average between 8:30 a.m. and 9:30 a.m., with the funeral home opening at 8 a.m. The employees arrive around 7:50 a.m. Respondent stated while walking into work, they have casually noted an unpleasant burning smell, while the crematory is not in operation. Respondent stated they believe the burning smell stems from the coffee roaster, not the crematory. Respondent stated while writing this response, an employee went outside and smelled the burning smell, knew it could not be the crematory because the machine was in the warm-up phase and was not burning a body. However, respondent stated out of an abundance of caution, they have contacted the crematory manufacturer who explained that the crematory, quote, burns off smoke and odor, end quote, and that the only way a smell of significance, quote, would be able to permeate to other buildings is if we had consistent black smoke and high winds to blow the smoke downwards, end quote. Respondent stated they rarely ever have black smoke, and when they do, it is within EPA limits, and that would require a consistently strong winds given the positioning of the smokestack. Based on the above, we'd recommend closure with a custom closure letter to complainant stating if they believe a problem continues to exist with the retort, specifically with this respondent, that closure letter will provide the manner in which they can contact the prevailing air pollution governmental agency that would have jurisdiction in that area.
Any discussion?
Make a motion, council's recommendation.
Second.
Motion to accept recommendation by Mr. Lee, second by Dr. Allen. All in favor signify by saying aye.
Aye.
Any opposed, like sign. Passes unanimously.
And the last complaint is complaint number 2026015361. Complainant, daughter of the decedent, stated that their parents had purchased a pre-funded funeral arrangement and were contacted to embalm the decedent and air transport them to Florida on February 6, 2026. Complainant stated they later called and were told that the decedent was scheduled to leave Tennessee on Monday, February 9th, 2026 at 2:30 p.m. and arrive in Florida at 3:44 p.m. However, complainant stated they received a text from the Florida establishment stating the decedent would not arrive until Tuesday, February 10th, 2026 at 8:44 a.m. Complainant called a respondent and claimed that they were told the Florida establishment had made the flight arrangements. In conferring with the Florida establishment, complainant was told that respondent had made the arrangements. Complainant informed the Florida establishment that their contract covered $350 for air transport, and the Florida establishment was asked if they would accept the airline bill, which they agreed without knowing a prearranged contract for airfare was in place. Complainant claimed when they brought this up to respondent, they said they could write a check to the Florida establishment for the $350. Respondent replied stating they initiated a call to the transport company on February 6, 2026 to initiate transport for the decedent's remains. Respondent states they were told the remains were at the airport by 11 a.m. on Monday, February 6, 2026 for a 2:37 departure to Atlanta. Respondent stated the transport company provided this information to the Florida establishment and that they were not involved with the second leg from Atlanta to Florida. Respondent stated it is common practice for this transport company to have the receiving funeral home pay the air charge to ensure there are no delays or problem in transit. Respondent stated they had a check for $350 waiting for complainant to pick up when she picked up the death certificates, and that the check was made out to complainant because she was the policyholder. Respondent stated they could not explain where the confusion regarding the second leg of the flight came, but offered their apologies, acknowledging that shipping of remains through air transport has its inherent challenges and difficulties. Respondent supplied documentation from the air transport company showing departure from Tennessee Airport on February 9th at 2:37 p.m. and arrival in Atlanta the same day at 3:44 p.m. The documentation shows the second leg of the travel is departing from Atlanta on February 10th at 7:30 a.m. and arriving in Florida the same day at 8:41 a.m. Based on the above, we would recommend closure.
Any discussion?
Motion to accept council's recommendation.
Second.
Motion by Mr. Lee, second by Dr. Allen. All in favor, please signify by saying aye.
Aye.
Any opposed, like sign? Passes unanimously. Thank you, Mr. Bryant.
Thank you.
At this time, we'll move to the Executive Director's report. Mr. Gribble.
Thank you, Vice President Nash, board members. The legislative update for today includes most of the bills that we had last meeting, but I think there's an additional one on here. However, in looking at the General Assembly website, it appears that only one bill has been assigned a public chapter, which means it passed, been put into law. But the bills that we're directly tracking, and realize also there will be other bills that will have effect or could have an effect on the board. Obviously, the council would tell us about. It might have to do with meeting notices, things of that nature. The ones we're tracking either directly or fairly directly affect funeral directors, pre-need sales, or cemeteries. So we've been tracking House Bill 2591, Senate Bill 2620 as one. Another one, House Bill 2307, Senate Bill 2274. The one we didn't have listed last month, I think, is House Bill 1286, Senate Bill 1145, which had to do with embalming a body or burying the body within 48 hours from the time when a person or agency waives the ability to request an autopsy or embalming of the body. Then we were tracking House Bill 2171, Senate Bill 2631 in regard to cemeteries, and the bill that passed and goes into effect July 1st and has a public chapter. It's Public Chapter 626. It's House Bill 1731 and Senate Bill 1841, and the public chapter has to do with a new definition for desecration of a body, which is removing objects from a place of burial by a person other than a family member or an authorized representative of the cemetery, an employee of the Department of Environment and Conservation's Division of Archaeology in the ordinary course of the employee's duties, or a person otherwise authorized to remove such objects. So it's in civil or not civil, but criminal offense. That one is passed and it's effective July the 1st. We were also tracking House Bill 2269, Senate Bill 2290 under probate law. Again, it appears out of those that we were directly tracking, only this one has got any significant movement to it. The license is issued as a report of license administratively approved by the executive director pursuant to board authority for the period of March 5, 2026 through April 10, 2026. And you can see those license of establishments and individuals that were issued there. Closed establishments, we have one establishment that reported closing since the last board meeting, Phillips Robinson Funeral Home, Hadley Chapel at 1700 Hadley Avenue in Old Hickory. And as far as complaints, the disciplinary actions, to report of consent orders have been administratively accepted or approved by the executive director pursuant to board authority, and those were reported on the February 2026 regulatory board's disciplinary action report. Complaint numbers, as of April 7, 2026, we had 88 complaints, 35 of those against funeral directors or embalmers and 53 against establishments. Also want to mention that we had thing, just for people that might be listening to this or viewing the video later, the Department of Health a few months ago instituted an email system for amendments for death certificates. And they've contacted us this week to ask us to remind everyone that that email address should not be shared with the public, that that's for funeral directors to amend the death certificates. And I think in instances, and I don't recall if in all instances there's a fee to be paid, but nevertheless, some funeral director shared the email address and there was supposed to have been a fee paid. And then the Department of Health gets caught in an awkward position, for lack of a better word. So they're just asking us to remind funeral directors and funeral establishments, they're wanting to help them. They want to be efficient, but it's not something that they can do for the general public. It's something the funeral director or the establishment should be doing. We failed on the agenda to do something that probably need to let Mr. Bryant do. And then I've got another comment after he does that, but I can finish my report. He's going to talk about a rulemaking update. And as we all recall, there was a rulemaking earlier, fees increase effective July the 1st, 2026. So the way to help people pay a less amount is on May the 2nd, the renewals will open for those who license expire June the 30th. So sometime between May the 2nd and June the 30th, they need to make sure they have completed all their requirements to renew. They need to make sure that they've made their application to renew, and they need to make sure that they've paid their money. If they do, then they pay the old fee. If they don't, they pay the new fee. And that means that if they fail to get their CE, then they're going to be subject to the new penalty, and then all the things that happen because of that. Also for the people whose license expire July the 31st, those renewals will open. Have to look at the calendar. They open 58 days ahead of time. So on June the 2nd or June the 3rd, then they can go in there and renew before June the 30th. So to alleviate some of the complaints that you hear, and you've been hearing now for months because people don't renew on time, there's a good incentive for them to go ahead and renew as soon as they can, do their continuing education and be finished with it. And then they can wait 2 years before they have to pay the higher fee to renew. Now, for the people whose license expire August and further on out, they're just subject to the new fee. That's why we had to do the new fee, is because of the deficit. So at some point we got to address the situation and move on. But just food for thought for those that would like to pay a less amount to renew. They need to do it as soon as the renewal opens. Now they can't do it ahead of time. They've got to wait until the renewal opens. Again, those that expire on June the 30th, the renewals will open about May 2nd or 3rd. And for the ones that expire July 31st, those renewals will open about June the 2nd or 3rd. And that concludes my report. I'll be glad to answer any questions you have.
Thank you, Mr. Gribble. Any discussion or questions for Mr. Gribble? Entertain a motion to accept his report.
Motion to accept.
Second.
Motion to accept the executive director's report by Mr. Wheeler, second by Mr. Haynes. All in favor signify by saying aye.
Aye.
All opposed, like sign. Do we need to go, Mr. Brian? I'm sorry, I skipped your
No.
rulemaking update.
Totally fine. A very brief update. Mr. Gribble already alluded to it. Those rule updates regarding fee increases will be effective July 1st of this year. We were able to, I've described previously the rulemaking process as about a 18, 19, 20 step process. And a lot of people did a lot of really great work to get that through as quickly as possible internally at the AG's office. And really the only final step we have is that it will go before government operations, which is routine for all of them. But pending any change there or any deviation from where we are, those will go into effect on July 1st. And that would be about a 10.5 month project, which for rulemaking is actually pretty quick. And just as a very brief update on a previous project, the retrospective rules, which we're required to re-examine just all of our rules, what fits, what's outdated, what do we need to update. Every handful of years, we look at that. Those have been made effective. We're good to go there. No further action. It's gone before government operations already, and those are already in place. So as far as rulemaking projects on the board's agenda, one's finished, one's checked off, and one is close to being so as well.
Thank you, Mr. Bryant. Any comments or questions for Mr. Bryant before we move on? Also, a housekeeping thing that I believe I skipped when I called to order the meeting is that if there is anyone at the end of the meeting, we will have an opportunity for public comments. If you're attending virtually, you let us know. We can do that as well. If you're attending here in person, you can sign up for public comments. I apologize for omitting that earlier. Mr. Gribble, we have any applicants to appear before the board?
We have one individual. It's Jimmy John Bowen of Laverne, Tennessee. He has an application pending before you for a funeral director's license. Mr. Bowen, if you will, just introduce yourself and tell them a little bit about yourself, and they may have some questions for you.
Yes, sir. First of all, thank you. It's an honor to be here with you all today. I see some familiar faces from our recent graduation from Gupton this last December. So I just want to say thank you. I'm very, very honored to be here with you all today. I go by JJ, by the way. Jimmy John is my legal name, but JJ is what I have been since I was knee-high to a grasshopper. I've accomplished many things throughout my life here. Bachelor's degree in music from Union University decades ago. Master's degree in business from Northeastern State University in Oklahoma, which is where I'm originally from. I'm a member of the Cherokee Nation of Oklahoma, so tribal member. Very proud of those accomplishments, but I think finishing Gupton and having the opportunity to potentially be a funeral director is probably my crowning achievement. It means more to me than anything that I've ever done. I feel like this profession is not just a profession, but it's true ministry. Since I've been working in a funeral establishment, I don't feel like I worked another day. It truly feels like a ministry to me. I feel like I'm in my element, that I feel closer to the divine, to God, when I'm doing those things. That's the only way I know to explain it. So with that, I am open to whatever questions you may have.
Board members, I will jump in real quick. Dr. Allen, I get to put you on the spot now. This is payback for earlier, but I have zero doubts about your ability to be impartial, but just to be on the safe side, I would recommend that you were recused from this application, just since Mr. Bowen was a student.
Board members, anybody have any questions for Mr. Bowen?
Not necessarily questions, but we all have all the documents. I don't think we need to read anything from there.
Okay.
And of course, the reason you're before the board is because one of the questions answered, Mr. Gribble couldn't approve without coming to us.
Yes, sir.
And I've noticed you've graduated Gupton, no problems. You finished your apprenticeship, no problems. And now you're trying to get your final license.
Yes, sir.
And I've read your recommendation letters and I've gone over everything else. And I don't have any more questions, but there was not a red flag or anything stopping the first two steps of this process. So I just wanted to make that known.
Thank you.
So just real quick, you served 2 years probation. That's all been taken care of, correct?
Yes, sir. Many
All
years
your
ago.
fines, everything's been paid, so there's no outstanding anything
That's
on
correct.
all that with the court.
Correct. It's been
Okay.
over 20-something years. Yes.
Okay. I figured it had been, but you always have to ask.
Yes, sir.
And you're just seeking your funeral director's license, correct?
That is correct, sir.
And do you have active employment? If you get your license, that you already have a job that you'll
Yes,
be
sir.
going into?
Yes.
Okay.
In your, well, first of all, thank you for being here today and thank you for taking the time to be here.
Thank
And,
you.
thank you for what, for, wanting to be in this profession because it's very important to all of us, as you can see, because we're here to, we serve on this board. And I just want to make sure I understand that with your agreement with the probation, and everything, it's so in the bottom of this judgment, it says that you were required to be on the registry. Did they amend that after you served out, you fulfilled your obligations? I guess?
Yeah, I was able to be off.
Okay.
Yeah, and I have been for some time.
Okay. I thought I had another question. I guess I don't. Sorry.
It's all right.
Mr. Bryant, do you have anything to add?
I do not. I will say these are with the legal aspect. Part of it is I kind of sense with you are where the board is. So I don't have anything to add specifically in terms of I've looked over documentation. Everything seems to be in order. If the board is inclined to go one way, I may have things to apprise the board of and make you all aware. But I'm realizing this is a very cryptic answer, but I do not have anything to provide at this time. If you all begin to go down one avenue, I may jump in and provide some info.
Anyone else have any questions for Mr. Bowen?
I'd just like to remind the board, just a couple months ago, we had someone before us getting their license that was not truthful on their application about a charge, and we approved their license. So I'd like to go ahead and make the motion. He has followed along. Everything's been filed and paid. I make the motion that the board accept his licensure for being a funeral director in the state of Tennessee.
I second that.
All right, Mr. Bowen's application for licensure has been the motion has been proposed by Mr. Wheeler, seconded by Mr. Lee. Any other discussion? All in favor, signify by saying aye. Aye. Any opposed, like sign? Congratulations.
Thank you.
Thank you.
We have any new business, Mr. Gribble?
No, sir, and there's no one that is physically in person signed to make any public comment. And Ms. Smith says there's no one online either that wants to make a public comment.
This time we'll take a motion to adjourn.
So moved.
Second.
All in favor, signify by saying aye.
Aye.
We are adjourned.